Okay, so I'll just introduce the panels that we have for this panel. We have Janine Benedict, Associate Dean for Academic Affairs at the Peter A. Allard School of Law at the University of British Columbia. And this is in the order we'll start our presentations. Maître
Carmen Rioux, Esquire, Quebec Crown Attorney, and Genevieve McInnes, Defense Counsel here in Ottawa, and Kathleen Dufour, Social Worker and General Manager of the Assistance Centres for Victims of Crime, the CAVACs of Outaouais, and the Honourable Justice Mary Corbett, QC, a retired judge of the Ontario Superior Court. I'm just going to start by asking each of the panelists a question, and then we'll have some dialogue. So I'll start with you, Professor Benedict. You've researched, taught, and written extensively on criminal law of sexual offences. Could you provide a brief overview of the salient aspects of the legal definition of consent and the available defences? And could you also please identify some of the most significant academic critiques of the current sexual assault law? Thank you.
Well, thank you very much, and I've been told I have 7 minutes to explain the law of consent to you and then critique it, so I'm going to do my very best to cover what I need to in that time. So as you already heard earlier this morning, the Criminal Code does contain a definition of consent for the purposes of sexual assault, and it defines consent as voluntary agreement to engage in sexual activity. The Code does not define non-consent, which is actually what the Crown has to prove as part of the actus reus of the offence. But the case law, and in particular the Supreme Court of Canada's decision in Ewanchuk, tells us that non-consent is a subjective state of mind. It's the subjective state of mind of the complainant not wanting the sexual activity in her own mind to take place. The Code also reminds us that no consent is obtained where the complainant is incapable of consenting to the sexual activity, and that includes incapacity on the grounds of intoxication or on the grounds of disability. And we're told, among other factors that vitiate consent, that there is no consent where the accused induces the complainant to engage in the sexual activity by abusing a position of trust or authority. And I mention those two latter vitiating conditions specifically because they're ones in the Code that I think are underdeveloped and where the threshold is so high that they're often not useful in the situations where they ought to apply. And I'll come back to that in a moment. Now, we also know that even in circumstances where the Crown is able to prove non-consent beyond a reasonable doubt, that may not be the end of the matter because it's open to the accused to raise a defense of mistake of fact, of honest belief in consent. But for this to succeed, and in particular for the defense to have an air of reality, legally it's not enough for the accused to say, well, I thought she wanted it. The accused has to be able to say that he thought that the complainant had affirmatively communicated that state of mind, that she had affirmatively communicated a yes. And so that's often when we describe our consent model in Canada as an affirmative consent standard, it's reflected there. It's not enough to say, I thought she wanted it, I thought she was into it, but you have to point to something that shows that a yes was actually communicated to you. And in addition, as we know, in order for that defense of mistake of fact to be made out, there must be evidence that the accused took reasonable steps to ascertain the presence of consent. And those steps ought to vary depending on the circumstances and may be higher in circumstances where the complainant is, for example, intoxicated or has an intellectual disability. So that's a very brief overview of the legal definition of consent and the defense of mistaken belief in consent. So let me take a few minutes just to reflect a bit on those definitions and some of the challenges and criticisms of those standards. I guess what I would say first is that any consent-based standard, no matter how progressive, places most of the attention and scrutiny on the words and actions of the complainant, the woman who is alleging she has been sexually assaulted. The Supreme Court of Canada in Ewanchuk said that the credibility of women's claims of non-consent could be evaluated in light of their actions and their behavior. So, yes, it's her subjective state of mind, but of course it's the responsibility of the court to determine whether her claims about her state of mind are valid. And we can do that by judging those claims against what she said and what she did at the time. And so if that is done in a way that is rooted in stereotypes about women, in myths about sexual assault, in mistaken assumptions about how a normal woman would behave or should behave when she has been sexually assaulted, then we have problems. And so really the issue is not so much the law on the books, but what the law on the books still allows judges and juries to do. And if we evaluate the credibility of women's claims of non-consent by measuring their actions and behaviors according to standards that are sexist, that are rooted in myths and stereotypes, the practical result will be that we will revive the corroboration requirement that has been expressly abolished by statute, and it will be impossible to convict without some kind of external corroboration, and even sometimes that will not be sufficient. We will revive the resistance requirement, which has again been abolished through revisions to the consent standard. It is not legally required that women physically resist, and it's not even legally required that women verbally resist, because passivity is not to be equated with consent. And we will create an impossible situation for women who are intoxicated, who will never be able to meet the standards that we place on them. So what will it take to address this? Well, let me just end by saying that we need to take a step back and recognize that claims of consent in sexual assault cases, which are seen as just a routine part of a sexual assault trial, are actually themselves really quite exceptional claims. When an accused argues that the complainant consented, he is saying that the complainant had consensual sexual activity and then turned around and cried rape to the police and everyone else and is now lying under oath in court. That's what it means to argue consent. And we treat this claim as routine, but in fact it calls very deeply on a sexist rape myth that false complaints are commonplace and put men at risk of wrongful conviction, despite the fact that the evidence does not bear that out at all. And we created a whole system of legal rules and definitions that were based on that myth. We might have dismantled them formally, but the attitudes remain. And so what I would like is for the claim of consent to be viewed as exceptional. Yes, it's open to the accused to argue that in this particular case, the myth is in fact reality, and this woman did bring a false complaint of sexual assault and is lying under oath. But that claim needs to be viewed by the criminal justice system with skepticism, right, as something that doesn't happen all the time and deserves to be treated as such. Instead, what I think we see, unfortunately, is increasingly the attitude that cases that are often described as he said, she said cases, that it's he said plus she said equals acquittal. And that's true even in cases that are just she said, where the accused doesn't testify. I see that term used as a label that seems to be applied to almost every kind of acquaintance sexual assault between adults, even when there is corroboration, even when there are other witnesses, even when the accused doesn't testify. That's a failure of belief in women and in women's claims about their own state of mind and their own unwillingness to engage in sexual activity. So I guess what I want to say to start this discussion is that our focus on non-consent in the sexual assault trial in and of itself is rooted in those very same myths and assumptions that we've tried formally to dismantle. And so we need to approach it with that in mind. So I'll stop there.
Thank you. Thank you very much. That's very helpful and very concise. Maître Roux.
Ms. Roux, are you? You have 28 years of experience as Crown Attorney. And in your opinion, what are the greatest challenges for the Crown in cases of sexual assault against adults? And how are those challenges comparable, if at all, to prosecutions of other offenses against the person? For example, a bar fight. I'm going to speak in French, and I'll try to speak slowly enough that it can be translated. Usually, when passion is involved, I speak faster. I'll try to remain somewhat calm. The question put to me could be answered in a very bookish, intellectual way. In the classic approach of a lawyer who is going to meet with witnesses. Over time, however, a bit like a patient goes to the hospital and notices that doctors are important people at the hospital. And specialists even more so. They have less time, and it's always the patient who tries to fit into the schedule of those doctors. Eventually, I realized that, like them, we are serving the people we meet with, and it's that approach that most removes us from the difficulties we may have in meeting our burden of proof as Crown Attorney in sexual assault cases. Let me explain. The victim is the chief witness. As you know, that is self-evident. And that person is the one who will make the difference in the case. They are not a professional witness. It's not like a police officer called upon to testify in connection with drug trafficking, for example. So the time you spend meeting with him or her, getting to know him or her better, will ensure that you have a better chance of getting the abuser convicted. So the approach needed, and it helps in Quebec where I practice because with the existing directives pertaining to sexual assault, the Crown Attorney who is to authorize, or not, the lawsuit against the abuser, meet with the victim before the complaint is lodged. So, in that context, in Quebec, we are allowed, even before the proceedings are undertaken, to meet with that person, get to know him or her, and understand what he or she went through. And obviously, after going through all the evidence compiled by the investigators, you already have an idea, at that point, about the crime, the individual who committed it, the person who underwent it, the rest of the evidence. But I would say that it's the prime moment to spend determining who that person is and telling him or her that you believe him or her. It's not a therapeutic meeting, the meeting between Crown Attorney and victim, but it needs to occur in order to determine to what extent, when you look at that person and tell him or her that you believe what he or she has said, it makes all the difference. Communication is established, trust is established, which, in my opinion, is necessary for the justice system to be motivating. Because you are, in a way, the entry point for those people. You are the first people they meet with associated with the justice system, not the police system that comes first before us. And if, through our attitude, we lack respect and don't listen, you can be sure that the witness won't be able to do their best in the courtroom. With that introduction done, I heard the person who went before me talk about myths and prejudices. So I just want to quickly read an excerpt from the Ewanchuk case that my colleague spoke about. And it's one of the last sentences from that decision, which dates back to 1999, and says, Such stereotypical assumptions, which we just mentioned, find their roots in many cultures, including their own. They no longer, however, find a place in Canadian law. Bad news, though. In 2017, they still exist. And Crown attorneys have the duty, when meeting with victims, to prepare them for when they testify about the fact that they exist and that, for understanding what they went through, they may be asked questions that, in law, go too far. Such as, what made you not lodge a complaint right away? They need to be prepared. That question may potentially be asked by the lawyer defending the abuser. And if the witness is not prepared to answer it, it's a question that, can you still hear me? That will surprise, that will cause discomfort, and, unfortunately, will direct the focus elsewhere than on the experience that he or she had and that he or she just described, with all of his or her strength, but quite weak in a system that is adversarial. So, the Crown attorney has the duty to also prepare him or her for not just testifying about what he or she went through, and to remind him or her that you are certain that he or she did, but it's up to us to ensure that this witness is focused on in the courtroom, and everything that may be difficult for him or her to go through, that he or she is, before being heard, long before being heard, not the day that he or she has to testify, but before, so had the possibility of being warned that, unfortunately, it is possible that, for understanding what he or she experienced and did not experience, he or she may have to explain things that, on the surface, even for us, may be hard to understand. But when you exhibit a bit of open-mindedness and find out how the traumatized individuals may later describe what they went through, it gives them every opportunity and may ultimately instill in the decision-maker, i.e. the judge or jury, all the confidence needed for convicting with a very, very heavy sentence that is beyond all reasonable doubt. Thank you very much. I just wanted to mention that in Quebec, we have the attorney who reviews the charges.
So it's like this pre-charge screening in Quebec, so that's not the same policy everywhere, but so it's an interesting perspective. Ms. McGuinness, based on your over a decade's work representing individuals charged with sexual assault related offenses, what, in your view, are the greatest challenges for defense counsel in these cases? And similar to the question I posed to your colleague, how do these challenges compare to representing clients in other matters such as assault?
Unpopular perspective, that of the accused in sexual assault proceedings. I'd just like to start out by making a few points with respect to the role of defense counsel, and particularly female defense counsel in representing individuals charged with sexual assault. I think this has come to a head, particularly following the Ghomeshi trial. There was a lot of media about that. I'd just like to emphasize a few points about the role defense counsel plays in the justice system. So first of all, we all know we have an adversarial system of justice. And what that means is that the truth-seeking function of our courts can't occur unless all parties have competent representation and equal access to litigation resources. So our system assumes that the defending party will test the evidence and bring alternate facts to light, and this is what guards against the risk of wrongful conviction. Second of all, the lawyer for the accused is constitutionally and professionally obliged, within the bounds of ethics and legality, to pursue any and all avenues of potential defense, however difficult these defenses may be. One of the most controversial aspects of sexual assault trials, and this is highlighted in the media surrounding the acquittal of Mr. Ghomeshi, of course, was the challenging of the complainant through cross-examination. It's important to recognize that failure to submit a complainant to a thorough cross-examination could easily result in a successful appeal. So our appellate courts, just as they enforce the statutory and common law limits placed on the cross-examination of a complainant, similarly, they recognize that failure to cross-examine a complainant may necessitate a new trial. So I'd just like to place that in context in light of recent media surrounding the role of defense counsel. In terms of what I find is unique about acting for clients charged with sexual assault, what stands out for me is how difficult it is to resolve sexual assault charges. And by resolve, I mean how difficult it is to have my client, I'm not suggesting I would advise them in a particular way, but guilty pleas are more rare in sexual assault cases than in other cases in my experience. And I'd be interested to hear from Madame Aucoin about whether there's any particular statistics on this, but as I understand it, most convictions are obtained as a result of a plea of guilt. We know that the conviction rate for sexual assaults are much lower. Generally speaking, I'd be interested to know how much lower the rates are for a plea of guilt to a sexual assault. Anecdotally, in terms of my experience, it's much, much lower as opposed to any kind of other offenses that my client may be facing. And this is one of the factors that I believe should be looked at from a policy perspective, is why are sexual assault charges not resolving at the same rate as other offenses? And I can tell you that from the perspective of the accused person, the main reason these charges are not resolving, meaning that accused individuals who are even theoretically willing to accept their guilt are not pleading guilty, is that the consequences of a plea are so staggering. The stigma of a sexual assault conviction is extremely high, both in and out of custody, and getting placed on a sex offender registry is for either 10 years or life is an incredible deterrent. So one of the suggestions I would make that anecdotally my clients indicate they would be willing to seek would be a kind of diversion or willingness of a Crown to have them plead to an assault simpliciter in return for demonstrated therapy or rehabilitation. And I think that could address some of the issues surrounding subjecting complainants to the trial process, having an accused potentially acquitted, whether guilty or not, and not availing himself of rehabilitative options that may have otherwise been available.
Thank you. That was very helpful. Madame Dufour.
Ms. Dufour, yes. Based on your 10 years of experience serving victims of crime, what, in your opinion, what are the greatest hurdles for victims involving the trial before the court? And also, what are their greatest, according to their stories to you, what are the greatest challenges for them? Okay. Well, I too will speak in French. I'll also try to speak very slowly. All right, so I have only 5 minutes to try telling you about all the major challenges that victims have when going through the proceedings before the court, the criminal court. Obviously, well, for us, we see what a pivotal point the trial is for a victim. So, imagine a victim being asked to describe an incident, a violent incident, a highly intimate incident, in an environment that he or she is not familiar with, and in the presence of players who are there to ask him or her questions, sometimes very, very, very difficult questions. And so, for him or her, it is an extremely important and very difficult stage. But even so, there are conditions that can be established to ensure that his or her experience is easier. Naturally, I'm repeating what has been said since this morning, how the continued existence of myths and prejudices contributes to erroneous perceptions about victims. Well, those myths and prejudices mean that what is still seen in 2017 is a difference in treatment, and I'm going to refer to it as that, between what are called true victims and victims who perhaps have a bit harder life. When I say true victims, we're talking about a sexual offense, for example, committed by a stranger with violence. So, at that point, we still see a difference of attention and support that will be offered to him or her, either by the police or by attorneys than, for example, a woman who has been a prostitute for a number of years and is sexually assaulted, or very seriously sexually assaulted. Obviously, her lifestyle at that time will be questioned. So for her, it's clearly a hurdle that gets added to the fact that reporting is extremely difficult. Well, what can be definitely seen, for us as well, is the importance of legal experts continuing to be trained about psychological reactions, ones that may arise following the trauma, that those reactions can obviously impact the quality of the testimony that can be given. My God, 1 minute left. Naturally, I think that you're all aware that the Canadian Victims' Bill of Rights contains different rights that victims have. The right to information. It has been stated, and the video also mentions, it has been stated the importance of victims being kept informed throughout the process. Accurate, appropriate information throughout the process will ensure that the victim has more realistic expectations from the system. That's tremendously important. The right to protection. That right includes, among other things, it refers to the use of testimonial aids. How can you ask a victim who has suffered sexual assault to testify in the presence of his or her abuser? So, I say loud and clear about what a huge difference is seen. A victim who is capable of testifying, for example, by video conference, by remote testimony, so a victim for whom care was taken to ask him or her what type of testimonial aid may be helpful, a huge difference is seen in what his or her experience before the court is like. His or her right to participation. You have to understand what he or she wishes, understand what he or she wants. It is a way for him or her to regain some power. Now, I can also talk about the long time frame between when the act is reported. I know that some figures have been mentioned, but unfortunately, I want to tell you that in this area, until recently, they talked about a 4-year time frame between an incident being reported to the police and a trial. Obviously, the Jordan case, it seems there is a change, that they're really going to try and expedite things. We no longer need to see times where the time frame is a bit longer as a deterrent for a victim. Sometimes the victim also needs to receive support, therapeutic support, to truly be capable for the reactions, the outcomes following the sexual assault to be somewhat lessened, for them to be able to deliver a full testimony. Yes, supported. In closing, I still have many things to say. But in closing, what is seen, as perhaps a factor that can help create a positive experience for a victim before the criminal court at the trial stage, is the support that he or she can receive from a multidisciplinary team. What I mean by that, I myself have seen. It's been about 20 years that I've been working with victims. I have seen a great improvement. In Quebec, we have the opportunity of having teams of attorneys in criminal proceedings dedicated to the issue, trained, and who are highly sensitive. There are also, we have police officers dedicated to the issue, trained and highly sensitive. And we've also developed close partnerships with them. So what is seen? A victim who is supported throughout the process by social workers who are very familiar with the workings of the system. So police officers, attorneys will support him or her. For the victim, it's like having a team around them the team that will give him or her the strength to be able to go through the entire process and the power to describe what happened to him or her. It is often his or her route that will make a very, very big difference in regaining his or her power and also in restoring his or her balance. So that's it. Thank you very much. That's excellent. A lot of suggestions.
I'll turn to Judge Corbett. Based on your 14 years' experience as a Superior Court trial judge in Toronto, what, in your view, are the greatest challenges for a judge in sexual assault cases against adult complainants, and how well equipped is the criminal justice system in dealing with these cases?
I think that there is a crisis of confidence in the criminal justice system in delivering it to sexual assault victims. And I think this comes from three different things. The first is not that we have proof beyond a reasonable doubt or that an accused person is presumed innocent. It comes from the nature of the adversary system. We have in Canada an adversarial system as opposed to what most countries in Europe have, which is an inquisitorial system. So it becomes more two-sided storytelling contest of which narrative is going to be more convincing. A judge is an impartial referee, and indeed it's the essential quality of being a judge is to be impartial. But the judge is inactive in a sense in the trial process. The judge normally doesn't question witnesses or get involved in any way. And I do not find the criminal justice system or a trial a search for truth. It's really a determination of the truth of the charges that are brought. And the function of the criminal justice system is essentially to give an accused person a fair trial. A witness does not have any nearly clear legal rights at the trial. There have been a lot of changes for victims before the trial, but at the trial, it's still extremely difficult given the nature of the adversary system. The second thing is that problem is the pervasiveness of sexist attitudes in society, and judges are not immune from these attitudes. We have the case of just about a year ago where Justice Camp, famous for his statement, "Why couldn't you just keep your knees together?" And he went on to observe that young women want to have sex, particularly if they're drunk. That brought me to the third issue that I see in the criminal justice system that needs to be changed. And it came about to me because I looked at the two cases that came up in the last 2 weeks. The first one was in Newfoundland, where a woman who had been drinking got a ride home with a uniformed police officer and went into her home, and she doesn't remember what happened because she'd been drinking, and the next thing you know, when she woke up, he was on top of her. And she said that she couldn't say whether she consented or not, but she didn't want to. In the case last week in Nova Scotia, it ended up being a similar kind of case where there was no evidence that the complainant did not consent. Now picture this. There's a taxi, and there's a woman in the taxi, and the police come over and see that this woman has a big bruise in her head, and there's the taxi driver holding a baseball bat. Well, is there any issue of consent? In the other case, the woman is half naked, her DNA is on his mouth, and he's zipping up his pants. Consent is an issue? The taxi driver, they're strangers? I think the problem comes with the definition of assault in the criminal code. It's not in your material, but the definition of consent is. And the definition starts off, a person commits an assault when, without the consent of another person, he applies force intentionally to that person. So the opening words of the offense are, without the consent of another person. Now, at common law, there was a distinction between assault and battery. And this definition came about in Canada because we got rid of the crime of battery. So that was a significant change. At common law, an assault was a willful attempt or threat to inflict injury on another, and battery was the unlawful touching of another person without justification or excuse. No mention of consent. So it's time to have a look at the definition of assault. Why couldn't an assault simply be defined as the intentional application of force that results in harm to another person? The criminal code could then go on to set out circumstances that will be deemed or will be sufficient to amount to harm. For example, it could incorporate the very things that are now in the code with respect to being incapacitated or incapable of giving consent, where you're forced to, or where there's a situation of pressure or duress. In other words, it has to be turned around. The judges in the Nova Scotia and Newfoundland case may not necessarily have been sexist or had expressed sexist views such as Justice Camp did. They may merely be looking at, I need to have proof beyond a reasonable doubt of a negative. And I think that has to change. I think consent should be a matter of defense. I also think that, my time is up, I also think that we have to distinguish between stranger sexual assault and not. So that would be one of the circumstances where consent would have to be a defense where the sexual activity was between strangers. There should be a different category of crime called perhaps domestic assault for situations where there is an ongoing sexual relationship. And I think of Gomeshi, for example. In that case, it was unusual because all of the women who testified had consented to the sex. Why were they laboriously cross-examined about their sexual relationship when he should have been charged with simple assault? So I think we have to make those distinctions, separate the crime, and make consent a defense. So there.